And just before this directive by President Buhari for ministers seeking elective offices to resign, the Court of Appeal set aside the judgment of the Federal High Court in Umuahia, which voided the provision of Section 84, subsection 12 of the Electoral Act 2022. In a judgment, a three-member panel of the court presided by Justice Hamma Akawu Barka held that the Federal High Court Umuahia had no jurisdiction to have entertained the case because the plaintiff, Nduka Edede, lacked the locus standi to have filed the suit in the first place. But while determining the appeal on the merit, the appellate court held that the provision is unconstitutional because it violates Section 42, subsection 1A of the Constitution and denied a class of Nigerian citizens their right to participate in election. One of the clauses, as stated in Section 84, subsection 12, is that anyone holding a political office must relinquish the position before they can be eligible to participate in the electoral process, either as a candidate or as a delegate. And joining us on the news to discuss the implications of the court's decision is a legal practitioner, Inibeye Effiong. Good to have you join us.
For having me.
So, first of all, in the judgment today, the court set aside this judgment by the Court of Appeal set aside the judgment of the Umuahia court because the person who filed the case in the first place lacked the locus standi. But there was also the tricky part, which was the issue of the merit, the fact that this case has merit. And I just want you to interpret that for us and the implication of that in terms of this particular section of the Electoral Act.
Thank you. The implication of the judgment of the Court of Appeal is that, technically speaking, because the judgment of the Federal High Court Umuahia, which was given in a very controversial circumstance, given that, one, the case was filed in Umuahia, a sort of unusual jurisdiction, and then it was filed by somebody who is barely unknown, and then it was determined so expeditiously, and then the National Assembly that passed this law was also not joined as a party. So there were issues clearly with that judgment. Now, since the Court of Appeal has today decided that the plaintiff who commenced that action was bereft of locus standi, and the court went ahead to set aside that judgment on the basis of lack of jurisdiction on grounds of the plaintiff not having the locus standi, the necessary capacity in law to sue. It therefore implies that that judgment no longer exists. But as you have rightly noted, there is somewhat an intriguing part of this, whereby the court went ahead to look at the merit of the argument to the effect that if the appeal were to be determined on the merit, Section 84 sub 12 of the Electoral Act 22 would be unconstitutional or is unconstitutional because, one, the provision of the Constitution is clear on the issue of resignation of persons seeking to run for office. And also that the restrictive nature of the tenor and language of Section 84 sub 12, which has circumscribed the impediment under that section to political appointees, is targeted at a certain class of individuals. And by law, you cannot make legislation that is biased, that is targeted at specific individuals. So I do agree with the Court of Appeal regarding the merit of the matter, because I have made this argument in the past, that when the National Assembly enacted Section 84 sub 12, the first problem that they failed to address was the lack of definition. There is no way in the Electoral Act 22 that defines the phrase political appointee. That phrase is nebulous within the context of that section. Does it, for example, include the governor of the central bank, who is a political appointee?
I was just going to go there because he has a case in court now. He says he's a public servant and not a political appointee. And I just want to ask what that statement from the court means for his case in court. I know we cannot preempt the case in court, but what does that mean for him?
My assessment is that this is not the end of the matter. Given the pronouncement of the appellate court today on the question of local standard, it may be necessary for the right litigant, by right I mean a plaintiff or a litigant who is possessed, who is vested with the necessary capacity with the local standard to approach the court to have a proper pronouncement on that matter. Otherwise, if the judgment of the Court of Appeal remains as it is, there will be some confusion as to whether Section 84 sub 12 of the Electoral Act is still in force or not, because the judgment of the lower court, which had nullified that section, which had cleared that section void, has been set aside technically. So regarding the question of the CBN governor, my position is that it goes beyond the argument of Section 84 sub 12. When you have somebody that is the custodian of the money of the country, the finances of the country, saying that he wants to run for office while still retaining his position as the governor of the central bank, without prejudice to whatever the court is going to decide, I find the audacity of Godwin Emefiele abominable. I find it intolerable. I find it very provocative. You cannot have the head of the central bank, the man that determines monetary policies, the man whose institution is supposed to warehouse sensitive electoral materials, the man that by the CBN Act, Section 7, Section 1, and 11, another section of the CBN Act, is required and expected to be independent. You cannot have that person coming out to say he wants to run for president.
All right.
So even without the request of Section 84 12, under the CBN Act, under paragraph 1, part 1 of the 5th schedule to the Constitution, Godwin Emefiele has put himself in a situation where his personal interest is now clearly conflicting with his duties and responsibilities as the governor of the central bank.
All right.
And that is in contravention of the code of conduct. So he had the duty under the law to resign. He had the moral duty to resign. He had the duty of common sense to resign.
Well, he has a case in court. He has a case in court. We'll see how that plays out. I just wish we could talk about separation of powers and whether the court has a right to set aside the law made by the National Assembly. But my time is up. Thank you so much for talking to us, legal practitioner Nduka Edede.
My pleasure always.